My name is Sharyn Eklund. My mother was subjected to exploitation and abuse by a guardian operating within the failed Massachusetts trial court system. I have tried to find judicial oversight and accountability for this failed system, but the governor fails to appoint sufficient judges. There is a shortage of clerical staff and clerks. There is no oversight of guardians who violate court rules and abuse and exploit the people whom they are designated to protect. The Massachusetts Family and Probate Court system has been failing for some time. In 2011, there were 11 judges scheduled to leave that year. And now this year, there are 25 judicial vacancies with greater than 1,300 less court employees. There was a hiring freeze put in place since 2008. One keeps asking, when will there be an oversight contingency that steps in to take over this failed court system? But there never appears to be an answer. There is no level playing field. Without substantial resources, one cannot confront an abusive guardianship. And even if one tries, the outcome is predetermined before stepping into the courtroom. On the few occasions that my sister and I had representation, this individual, charging more than $600 an hour, told us that the matter of arbitrarily forcing my mother from her home would be decided in favor of the guardian and that we should agree or face being denied access to see our mother. We were told that said guardian was doing this out of spite and that she would get away with such conduct. She brought 4 or 5 people with her and billed my mother to be subjected to unspeakable physical and emotional distress and submit to a chemical restraint in alleged belief that my mother would not be cognizant of her surroundings. This guardian's rushed, ill-conceived care plan backfired and harmed my mother. In my mother's situation and in the situation for other unfortunate individuals ensnared in the Massachusetts guardianship system, the probate court has a failing infrastructure, severe personnel problems, budget cuts, lack of guardianship oversight resulting in such conduct as guardians failing to file accountings, charging excessive fees, and breaching fiduciary duties, and using chemical restraints in violation of the Rogers cases, which have become a vehicle for assembly line and voluntary psychiatric drugging orders, and judges who rubber stamp whatever a guardian presents in order to clear their docket. The following is a brief synopsis of the abuse that my mother endured. This guardian ignored court rules and paid herself every month without court approval. She engaged in accounting irregularities, refused to be transparent, refused to turn over needed documentation for others to complete accountings, and not until I obtained a lawyer did the so-called guardian submit a preliminary accounting 2 years into this guardianship. She was remiss in turning over needed information for completion of my mother's final tax return. She ignored my mother's wishes on every level. She ignored my mother's repeated requests for this guardian to remove herself. And apparently this person lacked the personal and professional integrity to respect my mother and treat her as a human being. She violated such constitutional rights of my mother as notice and the right to attend hearings. My mother on more than one occasion asked to go to court to express her wishes to the judge, but the so-called guardian prevented her from going. She left my mother without funds for medication and clothing, such that my sister and I would have to cover for this neglect. She failed to remove less than adequate caregivers. Again, my sister and I would have to cover for her neglect. She failed to repair leaks from around the chimney into the living room and failed to address other home maintenance issues. She removed my mother from her home and forced her to travel twice a week for 1.5 months in the winter without proper winter clothing between non-ergonomically suited lodging in Tingsboro and Woburn, causing her severe emotional distress which exacerbated her heart conditions. She put my mother at risk by placing her in her home with an individual who was on medication for depression and who was mandated to undergo counseling for child abuse. She authorized a chemical restraint because my mother was distraught at being removed from her home, and then placed her back in her home 1.5 months later because the chemical restraint did not work, and my mother's cardiac issues were difficult to regulate. She threatened my sister and myself whenever we objected to this individual's care of my mother. She was threatening to throw my mother into a nursing home and to deny us access to see her. She engaged in unnecessary court actions to increase her fees. She used a health care agency liaison to protect herself from liability. She depleted estate assets to the extent that my mother was forced to stay in rehabilitation facilities from December of 2009 until her death in March 2010. Such callous action resulted in my mother losing more than 20 pounds and succumbing to a systemic infection that was less than adequately addressed in 2 of the 3 facilities. She failed to comprehend how sick my mother was until approximately